Good morning, everyone, dear clients and colleagues. Welcome to our webinar on a hot topic that is relevant for every commercial lawyer: EU regulations and commercial contracts, keeping up with legal updates. So this session will be recorded. You can see it again on unyer's YouTube channel that is accessible through unyer's website. My name is Johannes Teichmann. I'm a partner of the German law firm Luther, focusing on commercial contracts along the supply chain and distribution law. I'm hosting this webinar together with my friends from Fidal France, Pirola Italy, and KWR Austria. We are all part of unyer, an international organization of leading full-service law firms dedicated to seamless international advice to our clients. And so are our topics today. Our presenters will speak about EU regulations that are or will become relevant in all member states, and as you will see later, even beyond the EU borders. The first topic will be presented by our French colleagues with the title, How European Countries Are Dealing with Green Claims Before EU Green Claims Directive. France has already anticipated the directive with a legal framework that establishes standards for green labels and claims. It will be interesting to see the French experience. The second topic is high-risk AI systems, the Italian experience. It will be presented by our Italian colleagues. Italy is a first adopter of the EU's AI Act, and we are keen to hear their takeaways. The third topic will be presented by our Austrian colleagues, the Corporate Sustainability Due Diligence Directive. It will show us how companies are made responsible for their impact on society and the environment. The German listeners can compare this with their experiences on the Lieferketten-Sorgfaltspflichtengesetz. And last, but hopefully not least, I will present the last topic on the consideration of regulatory guidelines in customer and supplier contracts. This presentation shall explain the connection between regulatory guidelines and commercial contracts. If you have any questions, please feel free to share them through the Q&A section. We'll collect them and respond to them after the last presentation. So let us start now with the first topic. It will be presented by our French colleagues Nicolas Linaret and Julie Fégé-Katz. Nicolas is a senior counsel in the commercial law team of Fidal in Paris with a focus on commercial law and regulatory. He joined Fidal 1 year ago after having been general counsel with Unilever in France and at the Dutch head offices for a year. Julie is a senior associate in the commercial team of Fidal in Strasbourg with a focus on commercial law and regulatory. She joined Fidal 2.5 years ago after 6-year experience in competition law, both in private practice with Linklaters and in-house with L'Oréal. So Nicolas and Julie, the floor is yours.
Thank you, Johannes, and morning to everyone. Very happy to be part of the unyer team, sharing with you what is coming in terms of strategic topics in the years to come. So I am old enough to have known the times when marketing teams had no interest into the green and environmental claims, because it was not a priority for the consumer at these times. It is now obviously a priority for everyone, so meaning the consumers, the governments, the authorities, so for the Commission as well. So in terms of what, from the European perspective, how green claims have been covered, so it has started in 2005. So then the Commission was very shy because it was just part of the unfair commercial practices. There have been some provision added this year, in 2024 with the 2024/825 Directive on the green transition, so which has had some provision related to the green claims to the previous directives, including some social and environmental claims concepts to the scope of misleading practices and basically making the difference between environmental claims and sustainability level, for which the directive is now creating a specific and constraining framework, which is what we expect from the upcoming Green Claims Directive to emphasize. This directive is not voted yet, so there are some projects that have been shared publicly, other are non-publicly, and we have been access to. And the Green Claims Directive should create a new category of labels, the environmental labels, defined as sustainability level, covering only or predominantly environmental aspects of a product, a process, or a trailer, for which the text will set new conditions. What we know today is that compared to the first draft that we have seen last year's, the level, the degree of certification constraints will be lighter than in the first text. But still, there will be a certified third party will be needed to make a full claims assessment. And so the last non-public version of the directive has considerably simplified the assessment process. But still, that will be much more constraining than today. In terms of the vote will happen somewhere in the first quarter of next year, we think. And then there will be something like 24 to 36 months to implement for each country. So that's what we are expecting, and we will see later how to anticipate this change. But we thought with Julie it was interesting to get a view on the journey, the French journey, because it happens that for the last years we have more and more constraining frameworks around green claims. And so Julie will go through, and then we'll go back to the directive and the impact for you.
So the idea is that France already anticipated on the second directive that was mentioned by Nicolas, the Green Transition Directive, even before the transposition date, because as far as consumer law is concerned, environmental claims were already included within the scope of potential misleading claims by the French legal framework. So this includes claims regarding the environmental impact of the product, as well as claims regarding the scope of the advertiser's undertakings with respect to the environment. So all of this is already under the scrutiny of French courts and French administration. And we had also a major shift in 2020 on the environmental law aspects, because there were new provisions which provided for a mandatory public information system regarding labels and indices, including repairability and durability indices, energy labels, and environmental qualities and characteristics of products. So these are very regulated and cannot be used. They must be used in certain circumstances and cannot be used, obviously, when it's not in the right framework. Also, we can note that there is France enacted a strict regulatory framework for the use of the notion of carbon neutrality since 2023. So this is also a notion that cannot be used in any way by companies. Next slide, please. So what is interesting in France, because of this anticipation of the on the green transition, is that we have administrative bodies, public bodies that are dealing with the green transition for one, and controlling the advertising for the other, and they both together published this year and also last year a report regarding environmental claims, taking a lot of examples. It's very thorough and interesting. We didn't pick everything, but just some examples, just to show you how they interpret the potential misleading nature of green claims. And this is This is obviously not binding on courts, but it's a very good, it gives us a very good idea of how to use green claims and what can and cannot be done. So, for example, the words ecological, sustainable, which are used in a lot of commercial or advertising today. These bodies said in their report that these terms, when they are used in a general way without explanations, cannot be justified. And on the other hand, a claim such as sustainable can be made about the company's approach at large, but only if it is well balanced and evidenced. So they give, for example, they gave the example of advertising for an aerospace company, which claimed that it was ecologically sustainable or it was growing aerospace in a sustainable way. So this was deemed excessive and all-encompassing, as well as too unclear. They also gave a lot of examples and guidance about signs, labels, logos that are sometimes made up by companies to claim their environmental impact. And so this also it's also something that can only be used if their origin is clearly indicated, if there is no risk of confusion regarding their meaning, if they do not suggest that there was an official certification or accreditation. So this also cannot be used in all the ways that companies want to use them. Also, references to biodiversity or climate. So they said that they indicate that no product or service can claim to protect climate or the planet in a general way. This is obviously too big of a claim. And there was an example of an apple producer who claimed to be protecting biodiversity, or a real estate company claiming to commit to preserve biodiversity. It was judged to be far too absolute. And so all these notions and all other environmental claims, basically the idea is that they need to be, the company needs to be able to evidence what they claim, and to put all the information for the consumer on their website, and to be able obviously to evidence it in a very specific way, and not to be too general, too all-encompassing with their claims. So next slide, and I give the mic back to Nicholas.
Thank you, Julie. So, which is for which results and what to expect. So, as you have seen, the French legislative and regulatory framework has already paved the way for the French companies to pay closer attention to what is coming with the green claims. However, even if the approach from the, let's say, the French administration is quite educative, there are bodies looking at the way companies are greenwashing or not. So there is the French advertising agency, which is blocking many TV ads for greenwashing, and other kind of advertising in press, other support are the subject of a very prolific contentious activity. In May 2023, the French courts have published its report on the first major investigation into greenwashing of non-food products and services in France. Out of more than 1,000 establishments inspected, 1 in 4 was found to be in breach. More than 250 warnings, injunction, and even criminal and administrative proceedings were issued, depending on the seriousness of the breaches. So that is what will happen probably in all the European countries tomorrow, based on the European Directive on green claims. So just a memo on what is coming with the green claims directive in 3 pillars. There will be clear criteria on how companies should evidence their environmental claims and labels. There will be strong requirements for these claims and labels to be checked by an independent and accredited third party. And there will be new rules on governance of environmental labeling schemes to ensure that they are solid, transparent, and reliable. So meaning when the companies will make a new claims, and even after, they will have to go through a third party to certify the traceability of the allegation and whether it's still strong after a few years. Next slide, please. So how to anticipate? So obviously, this new EU directive will force the companies to get a step further in traceability and evidence requirements. The aim is to provide more transparency and trust for the consumers, but also more fair competition between companies. The situation where everyone in industry, in any kind of industry, as soon as they were reducing the use of some plastics, could claim that they were saving the planet or even helping to, is completely over. For any new environmental claims, you should not wait for, that is our advice, not wait for the new directive to start defining and implementing a process of technical support and traceability of the claim. You should start thinking about third parties which can certify the process and be moderate in your claims. But that should not prevent you to make strong claims. It can happen that you have invested a lot to reduce the environmental impacts of your products and services, and you're able to claim it. But everything is a matter of proportion and evidences. You should be also careful with the competition, avoiding to do the same in a direct or even indirect collaborative way at the same time, obviously, and challenge also your competitor when they are going too far. Local administration, local courts, and local advertising agencies are more and more active on this matter and are very pleased to show to the consumers and public authorities that are also acting for the planet. So, to summarize, green claim is coming, the directive. That will be a strong new requirements everywhere in Europe, implemented few months or years after in your respective countries. So watch out. And if you have any questions, please use the chat. We'll be happy to answer. And thanks, Julie. And so it's Johannes now.
Thank you very much, Julie and Nicolas, for this very interesting presentation where you gave our audience clear instructions how they should prepare for the upcoming regulatory guidelines, the regulatory framework. So it has really given us a very good taste what we can expect on an EU level in the future. And so will also be the next presentation. It will also be from some, let's say, pioneers from Italy. They will be speaking about their experience on the AI systems and the respective act. It will be presented by our Italian colleagues, Francesco Lamberti and Lorenzo Muzzi. Francesco is a partner with Pirola in Milan. His activities focused on commercial law and drafting of commercial contracts. Time to time, he is also involved in mergers and acquisitions transactions, both local and cross-border, restructuring operations and setting up of joint venture. Francesco has also strong expertise in compliance law, and he's a member of the supervisory board of several companies in Italy. Lorenzo is a partner with Pirola in Turin. He negotiates and drafts commercial agreements and works on M&A transactions and joint venture, especially in cross-border context. In addition, Lorenzo advises on corporate and corporate compliance matters in Italy. So Francesco and Lorenzo, we are excited to hear about your experience with the AI Act.
Thank you very much, Johannes. Good morning to everyone. And as anticipated by Johannes, our talk will cover the salient aspects of the Artificial Intelligence Act, aiming to build trust, minimize legal and financial risk, and future-proof its industries. For the time being in Italy, we have just a bill, not a final law, but I mean, it's a bill that is already under the approval of the government, and just 2 days ago, a set of amendments were required by the political parties to this bill of law. As you know, the Artificial Intelligence Act covers the development, supply and use of the artificial intelligence systems within the European Union, including European providers whose systems are used within the territory of European Union. The regulation provides for a classification of artificial intelligence system according to the level of their risks to the security and rights of individuals. There are 4 categories into which a different artificial intelligence system will be classified: unacceptable risk, high risk, limited risk, and minimal risk. The greater the risk inherent in the use of a given artificial intelligence system, the greater responsibility of those who develop and use the system will be constituted be, up to and including a ban on the use of application and technology whose risk is considered unacceptable. The first level of risk, the unacceptable risk systems, concern artificial intelligence systems that cannot be used in the European Union because their use would pose a threat to people, their lives and rights at work, and to health and safety. Some examples of unacceptable risk systems are social scoring, predictive policing, emotion recognition systems. The second level of risk is the high-risk system, and it's when the potential damage that this system can cause to health and safety and fundamental rights of citizens is highest, and includes, but is not limited to, system used to operate critical infrastructure, in education to determine a student's suitability for a certain school program, to filter resume of applicants or to monitor employees, to determine eligibility for health services, public or private. This category system involve the most adjustment for those who intend to introduce or use them within the European Union. In particular, according to the Artificial Intelligence Act, the providers of high-risk artificial intelligence systems must implement a risk management system, produce technical documentation of the system before it is placed on the market, and such documentation must be retained for 10 years. Provide transparent information to installers, provide for human supervisions of the systems, ensure the accuracy, robustness, and cybersecurity of the system, report any serious incidents to the supervisory authorities of their respective member states, and conduct the system's fundamental rights impact assessment. The third level of risk is the low-risk artificial intelligence systems, and includes all the systems that can influence the rights or wishes of users, but to a lesser extent than high-risk systems. The third level, the low-risk artificial intelligence systems must meet precise transparency objectives, among which is the obligation to inform users who are interacting with an artificial intelligence system so that they can choose whether or not to use it and are able to understand the consequence. Shortly, providers and users of such systems must provide clear, understandable, and accessible information. The last and fourth level of risk is the minimum risk artificial intelligence systems, and include most of the system already in use. The minimum risk artificial intelligence systems do not need any particular requirements. As I anticipated before, in Italy, there is already a bill of law, not a law, that is under the approval of the government. Indeed, the Italian government has been one of the first to address the issue of the artificial intelligence at political level, defining a precise national strategy for the next years, 2024-2026, supported by the presentation of a bill in line with the European regulation. With regard to this national strategy for the next 3 years, Italy has formulated 27 strategic actions, divided into 4 sectors involved in the strategy: education sector, research and public administration, enabling infrastructure sector, and company sector. With regard to the company sector, there are two fundamental actions. The first one related to the provision of locally rooted entities that can assist small and medium-sized companies in particular through the provision of innovation services aimed at guiding the many companies that lack the basic elements to be able to act consciously. The second strategic action of considerable value is the planned support for companies with the allocation of €1 billion to support startup and innovation companies based in Italy, operating in key sectors like cybersecurity and telecommunications, through co-investment or by acquiring direct or indirect participations in said companies. Johannes, can you move on the next slide, please? Thank you very much. But why should companies take artificial intelligence act seriously? For 5 fundamental reasons. The first one is the global impact and extraterritorial reach. In fact, like GDPR, the Artificial Intelligence Act has an extraterritorial scope, meaning it applies to companies outside the European Union if their artificial intelligence systems affect individuals within the Union. The second reason is the reputation and consumer trust. In an area where ethical considerations play a significant role in consumer decisions, adherence to the Artificial Intelligence Act can enhance a company's reputation and build consumer trust. The third reason is the legal and financial risk. Non-compliance with the European Act can result in substantial financial penalties similar to those seen with the GDPR violation. These penalties can significantly impact a company's bottom line and shareholder value. Moreover, the legal risks extend beyond fines, as failure to comply may result in litigation, regulatory investigations, and enforcement actions that can further tarnish a company's reputation and disrupt its operations. The fourth reason are the sanctions. In fact, the Artificial Intelligence Act provides for a system of very severe sanctions in the event of infringements, depending on the seriousness and nature of infringements, and are proportionate to the size and turnover of the responsible economic operator. The final and last reason is the future proofing and innovation. The Act encouraged the development of artificial intelligence in a safe, transparent, and accountable manner. The companies that proactively align their artificial intelligence practice with the Act's requirements can future-proof their operations against upcoming regulation in other jurisdictions, given the Europeans' role as a regulatory trendsetter. Additionally, compliance can drive innovation by encouraging the development of artificial intelligence that is not only technologically advanced, but also ethical, and socially responsible. So there are serious and very important reasons in order to consider the Artificial Intelligence Act, and in order to be prepared to comply with the requirements of this Act once will be approved in each country. I will leave the floor to my colleague Lorenzo, who will illustrate the following slides. Thank you very much.
Thank you very much, Francesco. Good morning, everybody. Yes, we are pioneers in AI compliance, but there is a long way to go, because based on a survey made in 2023 by University of Milan, the Polimi, only 8% of the Italian companies declared that they were compliant with AI. Let's say more specifically, declared that they had carried out a strategy to govern ethical risk related to artificial intelligence. So we are pioneers, but there are lots of things still to do, because we are at the very beginning of this changement that will be very dramatic. So what shall the companies do in order to be compliant with artificial intelligence? I will try to be very concise so as to not to take other time for our colleagues and to keep in the scheduled time. We have to carry out the three actions that you see in this slide. The companies have to make an assessment, a process review, and they adopt technology platform. The assessment will involve an in-depth analysis of the AI application used or to be or developed by the company in the various departments. So the scope of this phase is, as common in compliance issues, to make a map, an AI readiness map. So at the end of this phase, the company will have or should have an outcome consisting in an action plan, which shall include also an estimation of the investments that the company has to carry out or to invest in order to be AI compliant. Second action, process review. Once you have done the assessment, you need to change or to adopt, implement new policies, new processes, so as to be AI compliant. So we need to take into account any action that have to be carried out, not only in order to be AI compliant, but also in order to be more ethical, sustainable, and controlled. And take into account that once you have adopted and changes the processes, you can also state in the sustainability reports and in ESG initiative that you have carried out such action. Finally, this is not an action, but more a suggestion. We suggest companies to adopt technology platform. We have seen this with whistleblowing law. The market offers a wide range of platform tools manufactured, studied by suppliers. These platforms are the perfect and easiest way to carry out an AI compliance activity. Next slide, please. The actions that I talked before were referred to all companies, including suppliers, including deployers, so including all the actors of the AI, let's say, scenario. In this slide, we will talk about the specific actions that should be taken into account and carried out by the users. So the company that normally carry out activities, commercial or service activity, and that use artificial intelligence. So this slide is specifically addressed to taking into account some major changes that company has to adopt in their company. So it is somehow a slide that takes into account what the companies have to do, the users have to do once they have carried out the risk assessment. So first of all, they have to define a corporate policy for the selection, deployment, and management of the artificial intelligence systems, identifying roles and liabilities, responsibilities in the company. It is very important to appoint, or let's say to delegate the AI compliance management to one or more employees. Likewise, something is happening now for the GDPR or the other compliance law. You need to appoint one employee or more employees in order to manage the compliance with artificial intelligence. Second, companies have to create a catalog of AI systems in use and classify them according to the risk, as required by the AI Act. Needless to say that these classification and the consequences of this classification are different based on the type of risk. The higher is the risk, the more the things that I have to implement shall be adopted. Then we have to define a third-party risk management process. AI compliance often needs to ask help or to outsource or to delegate to third parties some action. So the companies need to adopt and to define expectation and compliance requirement regarding the use, the development, and the maintenance and upgrades of artificial intelligence systems. Then there is another point, which is that when using AI systems with consumers, the companies have to consider whether changes are required to the terms and conditions, policies, and notices regarding the paperwork and documents of the companies. And the companies has also to develop an explainability statement to enable the consumers to understand the decision-making processes under the AI systems. Finally, the employee training. Awareness is one of the pillars of AI Act, and awareness is not only related to the consumers, but especially to the employees of the company. A system in which there are policies, but employees are not aware of what they're going to do, what they have to do, is not consistent with the AI requirements. So thank you for your attending to this part of AI Italian experience. I leave the chair to Johannes.
Thank you very much, Francesco and Lorenzo. This was a very good insight into the Italian experience, and thank you also for letting us know how we should all prepare. I think this is very helpful for the audience. So let's jump to the third topic on the Corporate Sustainability Due Diligence Directive, CSDDD. It will be presented by our Austrian colleagues from KWR, Thomas Haber and Annika Kohler. Thomas has been a partner at KWR since 2017. He regularly advises well-known national and international clients in all aspects of corporate, commercial, and capital markets law, including commercial contracts, mergers and acquisitions, and corporate governance. He is also a Privatdozent, an associate professor, at the Institute for Corporate and Business Law of the University of Vienna. Annika is an attorney at law at KWR since 2024. She advises and supports clients in all areas of corporate and commercial law, as well as in antitrust law. Apart from her work as an attorney at law, she's an external lecturer at the Vienna University of Applied Science. So, Thomas and Annika, we look forward to your presentation on a controversially discussed directive.
So, thank you, Johannes. We are happy to present you some information about the Corporate Sustainability Due Diligence Directive, which is, however, part of a wider movement in the sense of corporate sustainability and corporate responsibility. The idea behind this concept is that there is generally a responsibility of companies for their impact on society, human rights, and the environment, which is often considered as a negative impact. So the idea is to prevent, mitigate, and also manage a possible negative impact. The due diligence directive is part of a wider strategy for the whole area of corporate sustainability and responsibility. For example, one part of this is a directive enacted in 2022 on corporate sustainability reporting, the so-called CSRD, which has to be or should have been transformed into national laws until July 2024. I know that there are several states, like France, for example, who have already enacted this and transformed it. There are other countries like Austria where this has not yet taken place. And And the topic here now is the Corporate Sustainability Due Diligence Directive, which was enacted just recently. Next slide, please. What was the process of this directive? It was quite a lengthy and complicated process due to very different interests which were articulated in the legislative process. First ideas for a directive already originated in 2020. A first draft was presented by the European Commission in 2022, and then a final draft was published in December 2023, which then, however, was rejected at quite a late stage because several countries, including also Germany and Austria, had concerns about too far reaching obligations on reporting and also on possible liability risks. So it was then finally enacted on the 25th of July of 2024, so just a few months ago, and must now be transformed into national law within a 2 years period. It is planned that there will be a gradual implementation, meaning that beginning from 2027, it will be applicable to the very large companies. I still see that we are on the wrong slide. I think we should be one slide further already. Yeah, here, thank you. So in 2027, beginning with very large companies with 5,000 employees and more than 1.5 billion euros turnover, and this will then decrease 2028 to 3,000 employees and 2029 then 1,000 employees. There will also be some additional support from the European Commission by way of a set of guidelines, which will, however, only be published in 2027. So this will happen quite late. It will be especially interesting for those countries like France or Germany who have already national laws in place. For example, in Germany, there is the so-called Lieferketten-Sorgfaltspflichtengesetz, where already big commentaries have been written on. So this will, of course, have to be adapted to the requirements of the directive. Next slide, please. What are the main aims of the directive? Well, the idea is to protect human rights and environmental standards against possible adverse impacts, as it's called in the directive. Also to harmonize the regulatory rules in the different EU member states. As I said, now there are some countries which have legislation in place and others which have nothing in place, basically, and to set consistent and harmonized standards for corporate due diligence in this respect. So the main idea is that companies should try to avoid and mitigate, at least, and where possible, end negative impacts on human rights and the environment in their entire chain of activities. So main term which is used in the directive is that of the chain of activities, which includes, on the one hand, the activities at the upstream level, the activities of upstream business partners, especially suppliers of goods, raw materials, etc. But it also basically includes activities of downstream business partners involved in the distribution, the transport, the storage, however, not the disposal of the goods. So the whole directive is based on a risk-based approach. So these risks should be identified and then appropriate measures should be taken. Next slide, please. The companies to which the rules will apply, as I said already, the thresholds have been raised, so it used to be lower thresholds, will, after full implementation of the directive, be companies with more than 1,000 employees and more than 550 million euros turnover worldwide. Also, large non-EU companies will be covered if they have more than 450 million euros turnover in the European Union. This means that from the wording of the directive, only rather big companies will be directly involved. However, it should be expected that also smaller, even small and medium-sized enterprises will be indirectly covered because they will probably face contractual clauses of the big companies where they will also be required to basically adhere to the rules of the directive in one respect or another. This is a topic on which I think we will also hear something from Johannes a bit later on. So around 5,000 companies will be directly affected, but we expect a larger number which will be indirectly affected. What are, next slide please, the possible advantages of the directive? Well, of course, in theory, they should provide for citizens a better protection of human rights, a healthier environment for future generations. Also, it should help customers make informed choices. It may also be interesting for companies because it can also be used as a marketing tool in some way if there are customers or even investors who are maybe especially interested in such sustainability-oriented investments. So they could be attracted. And of course, for developing countries, it should bring advantages because it should raise the level of protection of human rights and environmental standards. But on the other hand, of course, it should be noted that not everybody is happy about these possible future obligations because it is feared that there will be no level playing field with non-EU countries. It will create a huge bureaucratic and financial effort, and it might be a competitive disadvantage for the European industry, especially in periods of a crisis. So there are even movements who try to, like it has happened to other directives, postpone the implementation of the directive. We will see if this may produce any results. Annika, please. And next slide.
Thank you very much. So what are the obligations for companies? In general, the CSDDD states that companies directly affected must introduce an appropriate due diligence process based on human rights and also environmental aspects. So what does that mean? So in particular, before integrate the due diligence into the company's guidelines, companies will get aware with the provisions of the CSDDD for sure. They have to review also and check their corporate legal frameworks, policies, etc. And then they can integrate the due diligence into their company guidelines, procedures, and management systems. The next step will be conducting a risk analysis and identify potential or even actual adverse impacts. which means that the companies will have to know their data, analyze contracts, etc. If they identify adverse impacts, then they have either prevent or mitigate if these are potential adverse aspects and impacts, or they have to bring adverse impacts to an end if they are actual. They also have to provide remediation for actual adverse impacts and to monitor the effectiveness of the due diligence procedure carried out. And the CSDDD also provides for reporting once a year. So this is kind of the public communication of the due diligence carried out by the companies. Next slide, please. Here on this slide, we see the due diligence obligations the companies in scope have at a glance. We see what we don't see in this slide is that the first have to get aware with the provisions and review their existing corporate legal framework, and then they have to introduce a risk management and complaints procedure in their existing frameworks. They will have to do information procurement and then analyze the risks that can be found in this information and data, and have to do a risk assessment. If risks are discovered and identified, they have either to prevent or take remedial measures and then monitor these measures. Last step is the reporting once a year. Next slide, please. And here you see the risk management in detail. What does it mean? It means gaining an overview of the chain of activities based on important aspects. One important aspect is especially the industry, because there are high risk industries, especially the textile industry, for example. They also have to gain data regarding employees' turnover or certificates. After gaining this information, companies will have to do a risk assessment and also a prioritization of these gained information and risks, and then take the measures, as said, either prevention or take immediate actions in the event of actual negative impacts. Next slide, please. So what are the estimated costs resulting from the new rules? Companies have to face costs for compliance systems, IT systems. Here they have also have the focus that here there are synergies with the CSDR reporting, costs for complaint mechanism reporting, the costs for the contract adaptation for the reviews of the contracts. Maybe there has to be a supplier selection. And because tracking of the supply chain is often difficult, we highly recommend timely and foresighted planning that will be necessary for the companies, especially those that are directly affected. What always should bear in mind that the CSDDD as well as the CSRD, they are just one part of the EU's growing regulatory landscape, and I think we'll hear more of that from Johannes later on. Next slide, please. So regarding the liability, we distinguish between the administrative supervision and the civil liability. So first, the member states shall designate authorities to supervise and enforce the rules. Member states also have to provide for effective, appropriate, and dissuasive penalties, in particular fines up to 5% of the global net turnover. And decisions and sanctions, they must be published by the supervisory authority, called the naming and shaming. To ensure the coordinated approach, there will be a European network of the supervisory authorities. And in addition to this public enforcement of the CSDDD due diligence and reporting obligations, both EU and not EU companies within the scope of the CSDDD may face considerable liability risks, meaning that they can be held liable for damages caused to natural or legal persons if they fail to comply with the CSDDD's due diligence obligations to prevent or to end adverse identified impacts. The central provision here is Article 29 CSDDD, which provides for main criteria that shall lead to liability, because the national legislation on the civil liability is not harmonized. In particular, the member states shall ensure that the law of the member state is applied, especially towards third countries. And companies should also bear in mind that a breach of the CSDDD obligations might lead to a director's liability as well. Thank you very much for your attention.
Thank you very much, Thomas and Annika, for this excellent overview of the new directive. I think it will be an administrative burden for many of the companies, as we could see in Germany with the implementation of the German Lieferketten-Sorgfaltspflichtengesetz. I have the honor to do the last presentation, but also the challenge to do it in time and to do it fast, due to the fact that we are short before your lunch break. So I try to be very quick and precise. The presentation will be about the consideration of regulatory guidelines in customer and supplier contracts. The background is the EU sustainability strategy, the Green Deal. It leads to a massive regulatory framework with a number of regulations that are already in force or will come into force. We have heard about the CSDDD from Annika and Thomas. There are very important regulations like the General Product Safety Regulations and also the Battery Regulation, which actually is the first one that has been set out by the EU as part of its Green Deal. The regulatory requirements that are in force or will come into force over the next years will put a lot of pressure on all the market participants in the European Union. So regularly, they should review the requirements that are coming out from these regulations to see if they are compliant and if their products are compliant with such regulations. It is very important from a contractual perspective to pass on these relevant requirements along the supply chain for three reasons. Number one is to fulfill their own legal and contractual obligations, because many of the regulations provide for so-called pass-on obligations along the supply chain. Second, it is important to ensure that the products themselves comply with the legal requirements. And then nothing that is actually in the regulation. But thirdly, as a company, you should be able to assert recourse claims on a contractual basis in the event of violations. This is not something that is addressed by the regulations, how to do any recourse claims. It is subject to contract law and to tort law of the respective jurisdictions. And basically, if you have an international contract, it's difficult to determine the applicable law. For example, if you speak about a tort claim, and to know whether you actually have a recourse claim, what are the requirements are, is there any fault requirement, what is, for example, the statute of limitations. So we recommend to clearly set out these points in your supplier contracts. And then we speak about the 3 W's: who, what, where. So firstly, who should contractually implement the obligations? Many regulations link the obligations to the position of the company. So the size could be a decisive factor, as we heard from Annika and Thomas with the CSDDD, depending on the number of employees. But it can only be the company's own position in the supply chain. For example, if we look at the GPSR, there are different requirements depending on whether the market player is a manufacturer, an importer, distributor, provider of online marketplaces. All of them are subject to regulatory requirements. However, based on their standing in the supply chain, different requirements may apply. This leads, however, at the end of the day, if you pass on all these requirements, to an indirect application of the respective regulations, which means, for example, and this is something that we have seen with the Lieferketten-Sorgfaltspflichtengesetz, not only companies that directly fall under the application of the respective regulation are caught by the regulation, but also the upstream suppliers, because they receive these pass-on obligations from their customers with which they have to comply on a contractual basis. And this cannot only lead to companies being caught by a regulation where they would in the first place not fall under the scope, but it can also lead to an international application of the regulations. If, for example, you have, and this is not very rare, a Chinese supplier and you have to pass on your obligations along the supply chain, then you also have to pass on these obligations to your Chinese supplier, which indirectly leads to an application of the EU regulations in China. The second W is, what can I contractually implement? So firstly, of course, you can regulate the compliance with product safety related requirements. All the market participants can only put safe markets on the market, so such as standards. You can also include or should include an obligation to comply with regulatory laws into your contract, but you should also be cautious, because depending on the respective supplier, a mere reference to, let's say, the supplier has to comply with all regulatory requirements, or if you just reference a certain regulation, may not be sufficient. For example, if this supplier comes outside of the European Union, he does not know all the applicable requirements, and depending on the respective law and jurisdiction in which you are playing, this mere reference may be too vague and intransparent, which means that you have not specified the requirements correctly, in which case, if the supplier does not comply with such requirements, he wouldn't be in a material breach. So you need to be very cautious depending on the supplier that you are dealing with. Then something that comes out of the CSDDD, for example, you have to put in an obligation to comply with due diligence procedures and market surveillance obligations. And lastly, as I said, it's very important to include recourse claims, the bearing of recall costs and other damages in case you will be delivered unsafe or unlawful products. Lastly, where do you implement this contractually? So you have practically, let's say, 4 possibilities what you can do contractually. You have the framework agreements, you have the supplier code of conduct, you have the terms and conditions of purchase and quality assurance agreements. There is no black and white answer to say where to put what, but from a general rule of thumb, I would always say if you begin with the general terms and conditions of purchase, these should contain the general legal terms that are relevant for all purchases. They should not contain any product-specific terms if more product types are sourced. However, if you're just buying one certain product, then in this case, you could also put the product-specific requirements in the terms and conditions of purchase, but this is very rare. The terms and conditions, they should be very precise, but they should also be complete. This is why nowadays we definitely see longer terms and conditions of purchase. Then, secondly, the supplier code of conduct. The supplier code of conduct does not contain so much, I would say, legal terms. It more or less contains references to the values of the enterprise. And it could also and should also contain the social and environmental requirements, for example, that are stemming from the CSDDD and their respective national laws. Then you have the quality assurance agreements. The quality assurance agreements usually contain operational procedures, but they can and should also contain compliance with product-related regulatory requirements. So here in this case, the quality assurance agreements are different depending on your supplier and the products that you are sourcing. And make always sure when you draft quality assurance agreements that there is the right link. So a breach against an obligation in the quality assurance agreement should be considered a material defect that allows you to assert warranty and recourse claims on a contractual basis. And lastly, we have the framework agreement, which regularly contains a high level of the legal terms. It would be the roof of all the other documents and links them together. It can contain deviations from the other documents. And lastly, it can contain any supplier-specific requirements that are not yet contained in the other documents. Okay, that was it. I tried to be very brief through the commercial contracts in order to be able to finish this webinar almost in time. I would like, as we are at the end of today's webinar, thank you, the attendees, for staying with us already until now, and also thank you to my colleagues from Italy, from France, from Austria for their very interesting presentations. If you, the attendees, have any follow-up questions on these topics or any other commercial contracts related questions, feel free to reach out to the presenters directly. And also you may check our unyer page for legal blogs on international commercial topics. So thank you very much for your participation and hope to see you again on our next unyer webinar.